Hello, my name is Deborah Gonzalez and welcome to Solo Practice University. This is the intellectual property course, and this session is actually going to be focused on intellectual property and its use in representing musicians. So its real focus is music and law. As always, this presentation is for educational purposes only and does not constitute legal advice. It is recommended that you seek legal counsel for specific matters. Now, these upcoming sessions, the music and law, the art and law, film and television, all deal with that area of law called entertainment law. Today we're going to look at things like copyright protection for musicians, band formation, trademark and brand protection for the Music Act, publishing agreements and recording contracts, as well as look at the difference between an agent, a manager, and an attorney, and then legal effects of digital distribution and social media. So we've got a full comprehensive agenda for this, and let's get started. So the first thing is always, when it comes to music, it's the idea of the copyright, and this is where everything stems from. And it's really important to understand copyright in the context of representing musicians, because there's actually a number of copyrights that we have here. We begin with the copyright that deals with, the music and the lyrics, the composition and the lyrics of the song itself. And then there is another copyright in what we call the sound recording of the music. So, somebody may have rights, they've written the song, and then they get it registered with what is called a PRO, a performing rights organization, or they assign it to a song publisher or a music publisher, and the idea then is that the music publisher will get that music placed in different venues, whether a concert or whether a film or a TV. But it's important to know that there are those different copyrights, right? One in the sound recording, one in the music and composition itself. Now, the copyright will protect both. Now, it could be that the authors to both are the same. It could be that the authors to them are different. So it's important to know who owns what copyright when it comes to the music. It's also important to note that sometimes music is not created or composed by just one individual, but maybe a few members in a band or a couple of friends, other songwriters who have come in together to create this. And so there is something in music called a split sheet. And this is basically a document that the different songwriters sign that says, I wrote this, or I contributed this to the song, and so I'm entitled to 50, 20, 30, 70% of whatever royalties may come in from that music. And it's really important to have these split sheets, because when you register the song then with the Copyright Office, you need to submit to them, send them a copy of that split sheet so that they can understand who wrote what, okay? Now, copyright is also important in terms of the music industry because it lays out who can use what of the music of the song. And what we've seen is that, there is something very popular called sampling. And sampling is the idea of taking a little bit of one song and using it in another song. We do have sampling royalty payments, so it's not something that could be done for free. In the beginning, we had cases that said, well, it's a fair use. We're only taking a little bit. And you might hear people say, well, if you only take 6 seconds, you're going to be a fine. So anything under 6 seconds, you're okay. But that's not true, okay? You do need to pay a royalty for some of the sampling. So make sure you know, if you have a client who's going to be doing any sampling at all, that you have a clearance for that sample in that way, okay? So we want to make sure about that. So for more information on the copyrights, look at the first copyright section, and that will go much more into detail of this. But what is important is that your music act, your songwriter, your musician, your band, that they recognize that there's so much value in these copyrights, in this music, because that's where everything stems from as we go forward in this industry. The music industry is going through a very big transition. You know, it used to be we had the old studio concept, much like in movies. You had the big record labels. They did everything for the artists, from developing them to then getting them on the concert stage and all of these other things. We're not seeing that anymore. We're not seeing the big record labels doing that kind of investment and risk with some of these smaller artists or unknown artists. And so we're seeing that there's a lot of opportunities for these middlemen or these development companies to come in and actually develop the artist and then sell that artist's contract to a major record label. So one thing to keep in mind is that if you are going to be practicing in this area, you need to be kept up to date in what is happening in the actual industry. Very, very important. Now, besides the copyrights, which is where everything begins, there's also the issue that if you're not dealing with just a single songwriter or musician, but you're dealing with a band, a group of individuals who have come together, who sort of want to identify themselves as one entity, what are some of the things to take a look at there? And, you know, lots of times these bands, when they first come up to you, they'll say, well, we're just friends. We don't need a contract between us. But in fact, I always tell my clients, well, the contract actually preserves the friendship. So you do want a contract that talks about these are the members of the band. And it's also important to know who those members are, who constitutes that band in actuality. And so it's so important also to talk about things like if the band should actually register in some kind of corporate structure like an LLC, a limited liability company, which would give some personal liability protection to the individual band members. And it is a conversation that you want to make with them, because some of these band members may have been in the industry for a while. They may have personal assets such as homes. They may have children that they need to provide for. So it is a very important conversation to have with your clients as to whether they need that kind of protection or not. It's also important about the name, and this is where it connects with trademark. You know, trademark is about brand protection, and a band's name can also be utilized as the trademark, the way to identify that band and its music in commerce, in the marketplace. And there is a difference between the name of the band and the logo that they may be using. So you want to have that conversation as well and see if they've actually put the name in some kind of a logo, a graphical element. Are they using specific colors, or are they just using the words, okay? The trademark also allows them to generate some brand value, to create reputation and buzz for that, and helps them with the band development. So very, very important. But we've had a scenario where one of the band members actually registered the LLC and registered the trademark. And so the trademark was only under that individual's name. So when the band disbanded, as may happen, where some members may leave or the entire band disbands, because he owned the trademark in the name, he was able to recreate a completely different band with different band members, but still use the same name of the band. And that's because he owned the trademark. Nobody else in the band could have done that, only him, because he owned the trademark. Now, in the music industry, one of the biggest issues is this idea of contracts. Everything is done by contracts, and we know that this contract is basically the agreement, right, between two or more parties in which they basically lay out what it is that they intend to do, an acceptance, an offer, how each of them are going to benefit, and what are each of their responsibilities in terms of this contract. So it's to lay out in very clear and concise manner the terms to what these parties have agreed to. There are all kinds of contracts in the music industry. We begin with things like simple management contracts that may be between the agent and manager and the talent themselves. There are copyright assignments and ownership. So that split sheet is considered a contract that we talked about. There are membership agreements to the performance rights organizations, and those are considered contracts. There are labor agreements in some scenarios. So if your client may not be the singer-songwriter, but may be a studio musician, he may have to sign contracts in order to work on certain projects. So it's important to take a look at those. There are performance, concert, and touring contracts. So if they go on tour, you know, there are certain things that they have to sign. They may sign with a concert promoting company, for example, so you want to make sure of those terms. There are licensing contracts if they use their music in film or television, video games, etc. And then there are also foreign distribution agreements. You know, your client may actually sign with different distributors, one that's only US or one that's English speaking and one for the rest or different territories in the world. So it's important to take a look at that. So what I want to do now is I want to look at some specific contracts and some terms that are within them and what you need to take a look at. And the first ones that we're going to look at is the publishing contract or recording agreement, okay? Now, usually what happens is that a publisher wants to have exclusivity of the artist's music, right? Or the band's music. They want that exclusivity because they don't want many people going out there and trying to place this music, because then he might not get that opportunity that he was trying to get. So usually they'll talk about an exclusive contract, the artist with the publisher, okay? But the publisher is usually non-exclusive, meaning that the publisher may have many different artists that they are trying to sell the music for, okay? It will also lay out if it's a recording agreement, because the publisher is not always the same as the recording producer. They could be different individuals, or they could be the same. In the recording agreement, they actually lay out when, where, the how, and the whats and the whys of doing that sound recording of that music. It'll lay out when things are to be released, if they will be. It'll lay out what the artist's royalties will get. It'll lay out some of the recording costs, some of the publishing right, and whether or not there will be tour support for the recording once it is done. It is important to take a look at these and see, you know, what the advantages or disadvantages are for your particular artist. And many times, what I tell my clients is that usually that first recording contract sometimes may even have what they say a buyback provision, where they'll say, you know, if for $2.5 million you can get back all your copyrights for the songs on that recording. And so usually I tell my clients, unless you're really wedded to those recordings, just that's going to be the dues that you're going to pay to get your first recording out there in the music industry. And so you shouldn't get too attached to those first songs as you go forward, okay? Other things that are going to be in those contracts, things like video, digital, and technology rights. So can they stream the music online? Is it only by CD? Can they do downloads of it? Those kind of things. It'll talk about the use of masters when a song is recorded for the first time. That original master, that original recording is worth a lot of money. That's where the copyright is held, and that is where the licensing comes from, okay? The contract will also specify what compensation they will receive and the timing of that compensation. They'll talk about performance parameters, so if that artist is going to be expected to do a certain amount of performances based on where the publisher or the recording company has decided that that would be good for them, and other things that they may take a look at. Now, one of the key terms that has come up is this idea of the 360 rights, or the 360-degree rights. In these contracts. And what these rights basically say is that they are ancillary rights to the recording agreement. It usually means that the record label who recorded the song, this is passive participation for them, so they don't have to do anything to get this money. It runs anywhere from 20 to 30% of the revenue from any activity, and notice that this is beyond the recording itself. So what 360 rights actually do is say that whatever this artist does, if they are on a television show, if they do a speaking engagement, if they write a book, if they license their image on merchandise, then 20 to 30% of any of that goes back to the recording company, okay? Because their thought is, if it were not for us recording you, your music would not be out there. You would not have had this opportunity, okay? So this is now a standard in the industry. Usually you will see it in every contract, very rare, where there's a contract that doesn't talk about 360 rights. So let me just read to you what one of those clauses might actually sound like. If artist enters into an agreement with a third party involving any entertainment activity that would normally fall outside of the scope of the recording agreement, including without limitation, acting or name, likeness, or biographical use in motion pictures or television shows, books, tourings, endorsements, etc., artists shall pay to production company 25% of ancillary net receipts. In the event the production company secures the opportunity, production company and artist share equally 50-50. Now, in this scenario, this clause actually looks at two different circumstances. One where the production company did nothing, the artist got this opportunity, but the production company is still going to get money. But if the production company finds the opportunity, then they're going to get more money. They're going to share with the artist 50-50. Now, in the contracts that you see, these may be different percentages, but this is just one example for you to get a sense about what that language may actually sound like, okay? Now, one of the biggest issues is what affects the value of the ultimate music deal. And there's many things to keep in mind. One of them is the genre of the music. Is it country? Is it hip hop? Is it classic? Is it gospel? Is it contemporary religion? Each of these have a different value in the marketplace. And that connects it to the location of the music deal. So there are certain geographic locations that we say, okay, that's this genre of music. So most people, when they think of Nashville, they think of country. When they think of Atlanta, they'll think of hip hop and that kind of music, okay? Those geographic locations also add to what the value of that deal is. So I'll give you an example. In Nashville, it's considered, you know, pretty low cost. So a major record deal where they had actually a bidding war ended up being about $35,000, whereas in Atlanta with a hip hop deal where they can give a producer over $100,000 to lay just one track, the value of that deal is going to be anywhere from 5 to 10 times what the value of the deal was in Nashville, okay? So that just shows you how the influence of the genre and the influence of the location can impact the value of that deal. The buzz surrounding the artist, the more buzz the artist has, which shows that they're popular, which shows that people want to hear their music, the more valuable that artist is going to be versus someone that has no value out there at all. And you know, you look at the scenarios like Justin Bieber from the internet and his YouTube, and you have examples like that, very rare, but because of his popularity, then he got the record deal. And then the last factor to look at is the artist's team, the songwriter's team, the band's team, you know, how experienced they are in negotiation, where they have their contacts. This is all going to influence the value of that record deal for your client. So if you've never negotiated a record deal, I would suggest, again, partner with an experienced music entertainment attorney who has, so that you can get a sense of what, you know, what are the key factors, what are the terms, what's the language that's being used, and what are the standards in the industry for those kinds of deals. Very important to know these things before you go in and try to negotiate one of those deals on your own. So some things, just these simple contract reminders, you can use this as a checklist with your client. Number one, make sure that there is a contract. There are so many clients that come to me and, you know, they did the recording and it's a year later and now they have the contract and they don't agree at all with some of the terms, but they've already made the recording, okay? They're kind of stuck in that. So when a client comes to you, make sure they have a contract. It protects their most important creative asset, which is their talent, okay? So you want to make sure that they have that. Have your client read the entire contract. Have them read the fine print. Have them read it more than once. Have them ask you questions about this contract and have you review the contract as well. If they don't understand something or if they don't agree with it, make sure to talk with them and say, you know, don't sign it then. Let's see what we can do. We can go and talk to these people, but you want to make sure that they do understand what they're signing. Now, one thing to keep in mind as attorneys, we can only advise our clients, right? We can't make the ultimate decision for them. We can say, we think this is bad for you. We think this is good for you. Do you understand what this requires of you? But ultimately, their decision is theirs. Now, usually what I do with clients is if I give them advice and they want to go against the advice and they want to make their own decision, I have them sign that they have been advised to the contrary and that they will hold me harmless if they have consequences of this decision that they're making on their own in spite of any advice I may give them. And that just protects me from future malpractice lawsuits, things like that, because sometimes clients, they believe they know more than us and then they go ahead, they do something and then they want to turn around and blame us because we didn't stop them. But in reality, we can't stop them. It's their ultimate decision. So you want to be really, really careful about that when they do that, okay? Now, in your handout, I actually have some examples of some publishing agreement, different contract clauses there, either with single songs where they have to lay out the songs themselves, okay? What kind of rights that they're giving and handing over to a publishing company, to a record label. So this is just some sample language for you to take a look at to be aware of some of the things that are being out there, okay? So take a look at those that are there. You know, there is a clause here that talks about that the songwriter, that the talent gives their consent for their name and their likeness and their biographical use of their story to be used to promote the music out there. And it's really important because it's not just about the record company receiving that right, but the record company can then assign that right to its licensees and to other third parties that they may be working with. And it's important that your client understands this. It's also important to agree on what that biography is actually going to state, what the story is, okay, about your artist that is going to be used by the record company. So you want to have review of your profile, you want to have review of the bio, you want to have review of how your client is going to be portrayed out there, okay? Very important. The other thing that's important to note is that most of the times the artist cannot assign their performance requirements in the contract. They can assign their interest, meaning the money that they're going to receive from the contract, but they cannot assign their performance. They have to perform themselves, okay? So it's important to note that because the publishing company can assign its contract and basically sell its contract with this artist to another company, okay? And some other things to keep in mind. You know, sometimes the recording or the publishing contract comes across as saying personal services agreement, okay? And you want to be careful about that, just what those personal services are. And, you know, there are many individuals who are out there and they just are trying to pursue and create a new record company, and they might be downloading contracts from the internet and then just slightly manipulating it here and there. One of the things that I always do if a client comes to me and says, I have this publishing contract, I go on the internet, I Google the name of that record company, see what comes up on their website, see what comes up on Google, try to validate their credibility, even if their only exists. If they don't have a website, I immediately tell my client, do not sign. If we cannot find information on this company, do not sign. They might have just started, they might be a fly-by-night. Other things to keep in mind, if the company comes and says, well, you need to give us $20,000 for us to record this, okay, that's a red flag. Why are they asking for that money up front? Things that are going to be in the contract are things like terms, how long the contract may be. It may be for 3 years, it may be for 5 years, it may be indefinite for one particular song where that publisher is going to have, you know, rights into the copyrights for that song in perpetuity. So you need to take a look at that very carefully. You need to take a look at the territory. Sometimes you'll see the world or you'll see the universe, or some publishers may say, no, we only want the US, Canada, the UK, English-speaking countries. So it's important to take a look at that. The other thing when you're looking at a recording contract to remind your client about is that lots of times what the recording contract actually states is that that record company is going to upfront the money for the recording. It's going to upfront the money to do concerts, but that they're entitled to be reimbursed all the expenses that they put out, okay? And that the artist will not receive money until those expenses are paid off. So the recording company is really not going to lose, right? Because they're going to recoup their money back if it gets sold. If it doesn't get sold, then your client should not be held liable, should not have to pay back that money to the recording industry if the record or the album is just not successful. So make sure you take a look at that as well. To there. And the reason why I bring that up is, you know, sometimes these recording companies say, oh yeah, we're going to fly you out to Las Vegas on first class and we're going to give you this big highfalutin, you know, hotel room, and the costs keep adding thousands and thousands of dollars, but the client doesn't realize they have to pay that back. They have to pay that first class airfare ticket, and they have to pay that big, you know, very expensive hotel. So just be very frank and upfront with your clients about these issues, okay? So you have some examples there, and also that the contract should be signed by both. In order for it to be executed, it has to be signed by both, and you do need original documentation. So make sure your client knows that as well, that if they sign a contract, there should be actually 2 copies of that contract with original signatures on both of those contracts, one for your client, one for the recording industry. Another good practice that you can do is scan that contract once it's been signed and executed, put it into your client's file so that it's easy to find without having to then accumulate lots of paperwork. The original is the responsibility of your client. Sometimes your client will say, no, I don't want to hold this original. You hold it in my file, okay? But make sure you have those instructions by your client. If not, they are entitled to hold that original. Just caution them that they really do need to hold on to that and take care of it. Now, there are other things that you need to take a look at with these contracts. One of the things, mobile materials, you know, things like ringtones, how maybe the music might be used with smartphones, how that music can be downloaded, merchandising and licensing. There is a great article, you could Google it, it's called 42 Ways Musicians Can Make Money with Their Music. And it's really important to share this with your clients, because sometimes your clients think, well, there's only one way to make money, and that is to get that big hit and get the recording contract, and that's it. But there are other musicians that, you know, they want a comfortable life. They want to make 40, 60,000 and still be home in time for dinner and have that quality of life. So it's important also to know what are the goals of your particular client, and then explain to them or share with them different ways that they can actually make money and not necessarily just have that one-hit wonder, okay? Talk to them about the touring profit participation. What happens when they go on tour? They'll be responsible for paying all of those expenses, you know, so they have to pay that before they then get any of the profit. So if they want a big concert and they want the lights and the pyrotechnics and all of that, they have to understand that they are also paying for that upfront. T-shirts, things like that, and ancillary rights. So it's really important. The contract lays out everything. And one of the most important things in this music industry is that your client understands the contract and that you do as well. Now, there are a number of books out there. One is called, you know, Everything About the Music Business, and there are others in that arena, contracts for the music business. So there are all of these kinds of books out there that are sort of trying to help you get a sense and a handle on the music industry. Okay, so now what I want to do is I want to turn it over a little bit to this idea of what about representing talent. You know, the music industry is about intermediaries and gatekeepers. A lot of it is not only who you know, but then who knows you. And one of the things about being a music entertainment attorney is that you really have to be out there. People have to recognize your name. And so I want to go through the team that talent will need in order to be quite successful. Now, sometimes these team roles, I'm going to lay out 4 of them, but sometimes these team roles are actually done by just 2 people or maybe 3 people, so one person may have dual roles, but it's important to know what each function for each role is. And the 4 that we're going to go over is a personal manager, a business manager, an agent, and then the attorney. Now again, these might have multiple roles, but right now we're going to separate them out so that you can see them. And I want to begin with the personal manager. The personal manager is really that individual who takes that songwriter, who takes that musician, who takes that band, and is looking at developing their career for the long term, okay? Most of those who represent the talent who are on this team are going to be based not on an hourly rate or a flat fee rate, but more so on a percentage of gross income. And so for a personal manager, it could be anywhere from 15 to 20%. I've heard as much as 30% depending on what they do for them. And so in the handout, you have this photo of Myron Bernard, who is a very famous personal manager in the music industry, and he's here with Jackson Brown. You know, and personal managers can become celebrities in and of themselves. So here I give you the example of Irving Assoff. He's the chairman and CEO of Live Nation Entertainment. And in January 2012, he was named the most powerful figure in the music industry by Billboard, okay? And he works as a personal manager for artists that we all know, people like Christina Aguilera, Journey. He also became the CEO for Ticketmaster, and then became at the top of Billboard, and Billboard basically said that he is the game changer. So that's just a picture of Irving so that you can get a sense of him. So in their own right, personal managers can be extremely influential and powerful. And you know, if your client has a personal manager like Irving, your client is going to have certain advantages than having a personal manager that is much less known or not known at all. Okay, so it's important to keep that in mind. Now, sometimes what we have is, instead of a personal manager, there might be a management company. They're still dealing with artist development, but they have multiple artists, right? But one of the good things is that they also have staff that deal with specific aspects of monetizing that artist or commercializing that artist. So they might have a department that only deals with merchandising, a department that only deals with website development, another one that only deals with social media campaigns. So sometimes there's some advantages to a management company as well. But it all comes down to the person, your client's goals, what it is that they're trying to achieve. The second person on the team is who we call the business manager. And this is usually the CPA, the accountant, the person who's going to take care of all the financial stuff. They claim about 5% of the gross income. So if you think of, you know, the personal management manager, career development, the business management, or the finance, okay? So here's one, Bert Padell, quite well known as a business manager and accountant. There's that financial piece. His clients include Wendy Williams, Russell Simmons, Madonna, Sean Puffy Combs, Alicia Keys, Robert De Niro, Pink Floyd, Wyclef. So you see he has a whole run of the gamut. So here's a picture of Bert Padell so that you can get a sense of him. In your handout, it's in color, and you see he's a very colorful individual. Okay, then we have the agent, and the example that I give here is Jeremy Piven in the show Entourage, or if you think of Jerry Maguire in that show where he says, show me the money, the idea that the agent is always trying to find work for their clients. And they claim about 10% of the gross income that comes from the bookings that they make. And this is important because your client may have more than one agent. It doesn't necessarily mean that they're only going to have one agent. They may have an agent by territory. They may have an agent by genre of entertainment. So they might have a film agent and they might have a music agent. It all depends on them, okay? So that's the agent. Now, whereas the agent is trying to find jobs for your client, the personal manager is going to determine whether that job is good for your client in the long term. And the business manager may come in and say, well, you know, that's not enough money for that job for my client. We need to ask for more money. So that's the way that those three may interact. Now, the last group is the entertainment attorney. That's us. And here the focus would be on the legal transactions, negotiating those contracts. And again, the percentage for industry standard is about 5% of the gross income. Now, sometimes an attorney may be asked to be an agent or to be a manager, and things that you need to keep in mind is that agents must be licensed in most of the big markets. So New York, LA, even a place like Atlanta, Georgia, agents must be licensed. So if you're not licensed, you want to make sure that you don't put yourself out as an agent. That's different for a manager. A manager does not need to be licensed. Now, an attorney is considered that we are held to higher standards, right? We supposedly have gone through higher education, law school, we've passed the bar, we've had our qualifications really scrutinized, we have continuing legal education to make sure we're at the top of our game. We have a professional responsibility and an ethics code that we have to adhere to, and we also have to make sure about our practice and liability insurance. Sometimes when you're looking at your professional liability insurance, they may ask if you do practice entertainment law, if you need to have a special writer, or there might, your insurance premium may actually be a little higher than other insurance before other practice areas, simply because you're doing that entertainment piece, and that can have certain risk in and of itself. So as the entertainment attorney, you have to be very clear with your client what role you're going to play. Are you just going to do the legal transactions? Do you want to get into management and what that entails? So you have to be very, very specific with your client, okay? There are things that you have to keep in mind, like when does the attorney-client relationship begin between you and that songwriter? If they come to you, when do they become your client? When does the duty of confidentiality go in there? Keep in mind things like conflict of interest and whether there's a waiver, whether you can represent more than one artist. You need to make all that transparent and clear with your client. Also keep in mind our duty of competence. Again, if this is an area that's brand new for you, you've never represented a celebrity client before, this is new entertainment area for you, try to partner with a more experienced, seasoned entertainment attorney for your first few cases, for your first few clients, or at least have one that can consult with you to make sure that you are adhering to that duty of competence and you are doing everything you can for the benefit of that client. I remember listening to a presentation done by Judge Hatchett, and she actually sued her attorney who reviewed her contract for her reality show, Judge Hatchett, because afterwards she felt that she did not get everything that she was entitled to. She sued for malpractice and she won that case. So you want to be very, very careful about what you say you can or cannot do. Now, there are other rules to keep in mind with, such as, a lawyer shall not enter into a business transaction with the client unless, one, the transaction is fair and reasonable to the client, and two, the client is advised in writing that they should seek and be given a reasonable opportunity to seek the advice of independent legal counsel. In other words, they cannot rely on you on reviewing that contract if they want to do business with you. They need to find another attorney in order to review it. Yes, you can put sort of like a statement in the contract that they have been advised to go and review it with somebody else, that they have in fact reviewed it with somebody else and will hold you harmless, okay? Remember also that we must adhere to the American Bar Association model rules of professional conduct. And we have to be careful about advertising and solicitations about compensation and our retainer agreements. If we do an engagement letter with our clients, we have to be very specific as to whether we are being their agent, their manager, their attorney, or a combination of any of those, okay? One of the things to keep in mind also, there is an association of talent agents. If being an agent is something you're interested in, you've got the website there, take a look at it. In California, this falls under the jurisdiction of the Labor Commission, but not for New York. So just something to keep in mind. We have a case in New York, a 1951 case called Mandel versus Liebman, okay? And Mandel was a non-practicing attorney, and he sues for commissions as an agent for Lieberman. And actually, it's not an agent, but a manager. And he says that the agreement says he is the manager and personal representative. The lower court says that no, actually, since he's an attorney, this was a retainer for an attorney, and a client can fire an attorney at any time. The higher court says no, this wasn't an attorney retainer. This was an engagement letter for a manager, and that he is not an employment agency. So that language is very, very important, okay? I also want to share with you a case, Barr versus Rothberg. This was California, 1992. The Labor Commission, this is Roseanne Barr and Arlene Rothberg. And Arlene Rothberg claimed that there was no talent-agent relationship, that she basically was not required to be licensed, because what she did was help Roseanne focus on career goals, not necessarily go out and procure employment or specific gigs or projects for Roseanne to participate in. And Roseanne just didn't want to pay her the commission for that. She said, you know, you were acting as my agent, you need to be licensed, and since you're not licensed, I don't have to pay you. But the courts came out and said, no, she wasn't acting as your agent. She was actually giving you advice on your career. So Roseanne actually lost that particular case. There are some other cases in here that you can take a look at and find more. One of the things that your client may come up and ask you about is, you know, they have you as an attorney, and if you're not going to be their manager or agent, how can they find a good manager or agent to then represent them? And something to always go over with your client is make sure to review the credentials of this individual or this company. If they say that they can be an agent or a manager, find out who else they represented, what other artists, if those artists were in the same genre as your client is. Find out who their contacts are, what networks they run in, you know, what would be the strategy that they have for your client success. These are all questions that your client needs to ask the agent or manager, as well as their cost, you know. And just some red flags: if one of these individuals stop or don't return phone calls, they don't answer their emails, all of a sudden they're just too busy to meet with your client on things. Another red flag is if they don't know your client by their name, or they don't know what your client's projects are, or what kind of music your client does. If they get your client confused with another artist that they might be representing, or they just don't know how to market your artists, and they just don't get the jobs for your artists. These are all things that your artists need to be aware of, because your artist, your client and your artist can always fire them. Just because they sign that contract does not necessarily mean that they have to keep them on board as part of their team. This is a little different from a publishing contract and a record label who's then recording your client. But if these are the individuals that your client is hiring to help them, they have every right to then fire them if they feel they are not doing their job. One caution, though, is to make sure that they do that firing or terminate that contract based on the terms that are in the contract itself. And usually the contract will lay out, this contract can be terminated by either party if A, B, C, D. So make sure those are in there as well, okay? Now, in this world, as the music industry is changing, digital has really influenced it quite a bit. And I have this site here for digital distribution, music management in the digital world. And you have that YouTube site, excuse me, it lists over 200 different online social media platforms for musicians in today's world, in a way from helping them create and write their music, to recording their music, to promoting their music, to promoting their concerts. I mean, it's just amazing. You go through, it's just a few minutes, but it is amazing how many websites that go out. And you know, this was done a year or two ago, and so every year this becomes a little more outdated, because there are even more websites out there that review this. So just take a look at that site. I think it'd be interesting for you just to get a sense of all that is out there and all of the different opportunities there are for your client. So we've covered a lot about representing musicians in music and law and in the music industry. Of course, there's so much more that we just cannot cover in an hour. This just gives you a basic overview. So I invite you, if this is an area of your interest, to read more, to look at the books, to get involved. Most of the bar associations will have a section that focuses on entertainment lawyers. Visit them, go to a couple of their CLEs or a couple of their luncheons, talk to them, ask them about what it is that they're doing. And if you are in the industry, it's always good to keep networking and keeping abreast of all the latest that is happening as this industry changes, evolves, and grow. It's exciting and quite creative, so thank you.